What exactly is a protection order in South Africa, and what should you do if you need one, or if someone applies for one against you unfairly? Is a protection order just a court document, or can it actually protect you? South African law allows courts to issue protection orders to stop harmful conduct before the situation escalates any further. A protection order is a court order that tells another person to stop abusive, threatening, or harassing behavior. In South Africa, protection orders are mainly governed by the Domestic Violence Act or the Protection from Harassment Act. These orders are meant to protect people from future harm. And once an order is granted, the court may also authorize a warrant of arrest to be used if the court order is breached. So what makes a magistrate rule in favor of one side rather than the other? The court does not grant or refuse these orders randomly. It looks at the evidence and the legal test. A magistrate may rule for the applicant if the evidence shows on a balance of probabilities that the respondent has committed or is committing domestic violence or harassment. A magistrate may rule for the respondent if the allegations are not properly proved, if the facts do not fit the correct act, or if the conduct does not legally amount to harassment or domestic violence. In harassment matters, the court also considers whether the conduct was reasonable in the circumstances. What if a protection order is filed against you and you believe it is false, unfair, or even exaggerated? If someone applies for a protection order against you unfairly, do not ignore it. You should appear on the return date and oppose the application properly. The court can consider affidavits and, where necessary, oral evidence. If there is no real merit to the application, the respondent can challenge the allegations, place their own version before the court, and, where appropriate on legal advice, raise absolution from the instance and argue that there is no proper case to answer to. A granted order may also be varied or set aside on notice and for good cause. The worst thing a respondent can do is ignore court papers. How do you actually apply for a protection order in South Africa? The process is meant to be accessible through the magistrate's court. You usually apply through the magistrate's court by completing the prescribed form and affidavit with the help of the clerk of the court. For harassment matters, you may apply where you or the respondent live, work, or where the incident happened. If the court believes urgent protection is needed, it may grant an interim protection order, serve the respondent, and then set a return date for the matter to be decided. Protection orders are powerful legal tools, but they must be used correctly. Whether you need protection from domestic violence or harassment, or whether you need to defend yourself against an unfair application, the legal process must be handled carefully. For trusted advice on applying for, opposing, varying, or setting aside a protection order, contact 𝗂𝗏𝗄𝗃 attorneys, protection order, and criminal law specialists at www.𝗂𝗏𝗄𝗃attorneys.co.za and follow us for more practical legal insights.